Tonight, in the trial of Oscar Pistorius, his defence witness faces ridicule.
For an expert, that's worrying.
The scientist on the spot in court.
Difficult question to answer, my lady.
I'm going to be rude because you don't listen. The question was, is he an expert?
Mr. Nell,
Yes, my lady.
please restrain yourself.
Good evening from Pretoria, where Oscar Pistorius has resumed his role as an onlooker in court today as his legal team continue to call other witnesses in his defence. That's meant that the forensic geologist Roger Dixon has continued his testimony about the bullets fired that night and the similarity of sounds of a cricket bat hitting the toilet door and of a gun firing. Pistorius, of course, doesn't deny firing the fatal shots which killed Reeva Steenkamp, but he maintains it was a tragic accident. State Prosecutor Harry Nell has kept up his aggressive cross-examination, really questioning whether Mr. Dixon was any kind of expert at all. Lisa Holland's been watching Mr. Dixon's uncomfortable day in the witness box.
Oscar Pistorius spent more than a week on the stand, denying he murdered his girlfriend. Now his lawyer, Barry Rue, is calling defence witnesses to back up the athlete's version of events. The prosecution claims 29-year-old Reeva Steenkamp was killed after the couple had an argument on Valentine's Day last year.
Would come from that direction and on the inside.
Forensic expert Roger Dixon said he believed Miss Steenkamp had been shot in quick succession and had been standing at an angle behind the toilet door. His testimony challenges the state's version that Miss Steenkamp would have had time to scream after the first bullet.
The body was closest to the door with the hip wound, consistent with bullet hole A. Approximately the same distance from the door when the arm was hit. And then falling backwards would explain why there is no splinters in the hand or the head. As the deceased was falling, there were 4 shots in rapid succession, and they hit as she was falling and turning, and by the time the head had reached the height, approximately, I would say about 89, E hit at 89 centimeters on the wall, approximately that height. The bullet wound to the head, 4.1, would be inflicted, and that is happening as the person is hitting the magazine rack and ending up on the floor, head going forward, resting against the toilet bowl.
After an hour of defence questioning, Mr. Dixon spent the rest of the day under intense cross-examination from the prosecutor Harry Nell, who attempted to demolish his credibility and his analysis.
You qualified as a geologist, am I right?
My first degree was in chemistry and geology.
And geology, yes. You obtained a master's in geology.
Yes, I did, my lady.
And currently, where are you employed currently?
At present, I'm employed at the University of Pretoria in the Department of Geology.
I see that you're currently not affiliated to any forensic body.
That is so, my lady.
Harry Nell then began to inspect the witnesses' expert credentials.
You gave evidence on sound. Are you a sound expert? Just answer that question.
I would hope that my evidence that I present is sound, yes.
Your analysis of visibility in the dark, did that require any expert skill?
My lady, the instruments I used there were my eyes. It's what is visible. I'm not measuring light levels, because to translate a light level so many lux into what you can see depends on so many things. And of course, I'm not an expert in the exact, precise measurement of light levels. I did not use a machine.
Your visibility in the dark test, you just used your own eyes.
I used my eyes, my lady.
Are you a blood spatter expert?
I have received no training in blood spatter analysis, my lady. What I've testified on now was that information was gained as a result of the reports by other expert witnesses who are specialists in their area, and putting together that plus my own investigation of the door, looking at bullet fragments, looking at all the photographs that were at my disposal and the scene. What I did is I reconstructed a logical, for myself, based on my knowledge and experience, a logical sequence of events.
The witness appeared to become confused as Harry Nell doggedly dissected his evidence.
Difficult question to answer, my lady, because I cannot remember specific differences. I do remember, however, that as the case progressed and more information looking at photographs, interpretations might have changed or did change in my case, but I cannot mention specific differences.
The defence lawyer Barry Rue had earlier played the court a series of sound tests to show a gun firing compared to a cricket bat used by Oscar Pistorius to break the toilet door down to get to Riva Steenkamp after he had shot her. The defence claims witnesses are confusing the sounds and therefore the sequence of events. First, the cricket bat hitting a door at a distance of 60 metres. Then at 180 metres.
There was also a test done with the firing the firearm. This is at 60 metres. And at 180 metres. Would that accord with the test that you attended?
My lady, the first ones were the cricket bat at 60 and 180, and the second ones were the gunshots at 60 and 80, yes.
The sound tests provoked fierce cross-examination by Mr. Nell.
We just wanted a recording.
So you felt it's, as far as a scientific expert is concerned, that's enough. If we can play a sound clip and I hit the bat, that's enough. Do you think that's enough?
Yes, my lady. For the purposes of that test, I consider that to be enough.
Mr. Dixon then admitted he hadn't in fact been present when all the gunshot tests were conducted.
Mr. Dixon, really, take it from me. I'm testing your integrity. You can take it. The gunshots we heard could not have happened on the night that you were on the shooting range with a bat, because we have rapid shots, and that did not happen on that night. Am I right?
You are right, my lady. There was no design and intent to mislead the court or the prosecution or the defence as to the nature of what we have done.
Then back to Mr. Dixon's expertise.
You're not an expert on wound ballistics, are you?
No, my lady, I'm not an expert on wound ballistics.
The relentless blows drew a reprimand from the judge.
Be an expert, assist the court. Please.
My lady, I went on the internet to listen to sound bites that are used by people when they dub them into movies and so on. There are libraries on the internet of different sounds, wood breaking, bats hitting, this, that, and the other thing.
I asked you a different question. I'm not stop you. You know, I'm going to be rude because you don't listen. The question was, is he an expert?
Mr. Nell.
Yes, my lady.
Please restrain yourself.
I will, my lady.
Then Mr. Dixon revealed he had only closely photographed the toilet door, centerpiece of the forensic evidence, last month, more than a year after Riva Steenkamp's death.
I had seen the mark on the door. I had seen photographs taken on the day of the event by the police of the mark on the door. However, when I saw it in the court with the lighting and it was highly visible, I thought, yes, that is nice. I did not have the opportunity with good lighting and a good camera to take it beforehand.
And you exclude that could be fibers of a mutton cloth used in cleaning this door.
My lady, I did not observe the cleaners putting an excessive amount of energy into cleaning the door, because that is caused by a strong blow. So I stay by my conclusion that those fibers were caused by the sock that was worn on the prosthesis and not by a cleaner with a mutton cloth.
In a few minutes, we're going to be discussing the defence strategy as the Pistorius trial enters its final phase. First, Roger Dixon finished his evidence today, giving his opinion on the wounds that Reeva Steenkamp suffered.
Your view of the blue marks on the buttock. You weren't at the post-mortem. What did you rely on, where that mark is described?
I looked at the description made by Professor Simon in his post-mortem report. The medial aspect of the right buttock displays an irregular area of contusion and blue discoloration of the skin over an area measuring approximately 40 by 30 millimeters with indistinct lateral extension thereof. External palpation does not reveal the obvious presence of underlying subcutaneous foreign objects.
And based on that, you said that it could be a bruise, and she fell against the magazine rack.
Based on the photograph, plus this information, plus my reconstruction of events, the magazine rack, that is how I interpret it, yes, my lady.
Did you take anything else into account, or was that about it?
I'm not aware that there was much else available about that.
You'll be surprised.
Okay.
Keep paging in that document.
What?
I just want to
Page
put on record,
89.
you said, what? Am I right? I want to put that on record. You opened that document and you said, what? Am I right? You opened that document, you looked at paragraph and you said, what? But let us read it.
Deep dissection of the right gluteal region following a posterior approach reveals irregular wound tracts but yielding only small irregular shrapnel metal fragments confirmed by transillumination. Extensive deep and posterior hematoma formation is present.
There he describes it. You missed it. You, Mr. Dixon, just made an inference without even reading the document that you referred to. There he described what caused that. He dissected that whole area, but you are strong enough to tell the court you know better.
In my layman's understanding, if the bullet had broken up into many little pieces and there was extensive hematoma and so on, and it had come to the surface, it would have discolored a large area rather than being two lines that intersect.
You see, Mr. Dixon, now you call yourself a layman. You gave the evidence. You were strong about that. You see how irresponsible it is to make inferences in areas where you're not an expert. It's irresponsible. Am I right?
My lady, I was interpreting the marks that I saw.
And you interpreted to fit your case.
So I have a scenario which I was recreating.
You see, the most irresponsible thing is if you refer to a document and you don't even read the full document. Why would you come to court, to the High Court, give this evidence, and you don't even read the full document? Why would you do that, Mr. Dixon?
After a week of Oscar Pistorius in the witness box, it was the turn of more defence witnesses today. And to discuss the latest day in court, I'm joined by Alex Crawford, our correspondent, Lobo Das Neves, who's a law enforcement expert, Llewellyn Lewis, of course, who's been giving us legal analysis all the way through this. And Alex, just give us an idea of what today was like in court. It was certainly a lot quieter after the last week.
Well, it didn't have the great drama that we've seen when Oscar Pistorius was giving his evidence. This was much more technical. It was much more finite. He was going through various details. But it was a bit like watching someone having their fingernails pulled out one by one as the prosecutor laid into the defence witness and basically tore his credibility, his credentials, questioned his integrity, and said at one stage, you don't appear to be an expert in any of these fields which you've testified in, and that is the danger of pretending you're an expert, basically was what he was saying. It was not a pretty sight.
Lobo, you've been an expert. You've given evidence in court as a policeman and as a lay expert. So what does it take to be an expert, and what are the dangers if you're not quite expert?
Well, expert really is what the word means, is knowing more than other people knowledgeable in that field. And the danger is sometimes it's hard to admit that you don't know something. And I think the one element of a good expert is to know when to and when not to testify in court, when to say no to a case. When you look at evidence and you see it doesn't really fit what the client, if you're a private expert, what the client's version is, then you just say, listen, I can't do this. But to go in front of an open court and purport to be an expert in a field we are clearly not is very, very dangerous.
Opinion evidence is admissible in court. But remember, it's still opinion. The ultimate discretion is still with the court to decide which evidence to allow and to assimilate and so on.
Well, and what's the point of it today, and what were the pluses and minuses of the defence putting Mr. Dixon in court today?
If we look at the weight of the evidence to be attached to the evidence of Roger Dixon, obviously because his credibility is basically out of the door, and let's call a spade, he did not stood up to the cross-examination. I don't think a court is going to allow much weight to be attached to his evidence. So we are back to square one from the perspective of the defence. They still only have Oscar Pistorius' version before court, which we know by now also was not that satisfactory all in all. And that's where we stand.
How crucial is it in this case, the finer points of ballistics? After all, we have at the centre of the case a man who admits firing 4 shots and somebody died as a result.
Well, the sequence of the shots are important. And the reason for this is that it is commonly known that with pain, people make a noise. And the first round hit the deceased in the hip, which would have caused an immense amount of pain.
You've been hit yourself, so you know.
Yes.
Tell us.
And it depends where the bullet strikes. It can be very painful. And it's very hard keeping quiet when you are in such pain. Now, when a weapon is fired, even in a confined space, and when you have that ringing noise in the ears, you can still hear. It doesn't make you totally deaf. You can still hear people speak to you. Even on the shooting range, if you forget to put your ear protection on, you can still hear people speak to you. So there's a question over what did Oscar Pistorius hear after the first round was fired, and what made him fire the other 3 after the first round was fired.
You remember the initial defense put up there by Oscar Pistorius is one of self-defense, putative self-defense. And in order to be successful in that defense, you must prove that there was an imminent danger and that you only continued for as long as that danger was facing you, confronting you. Now, suggesting that he could hear Riva Steenkamp shouting or screaming after the first shot, as indicated, I mean, then he should have stopped.
Tests were being carried out on a door, which had, in the meantime, been cleaned when it was in court and so on. So it does raise some questions.
I mean, several things that struck me was that how much of the gathering of evidence or research was being done so late in the day by the defence.
Once the trial had started, yes.
Apparently, Roger Dixon came in after the trial had started to take pictures of the door to try and match the marks or further match the marks of the bat against the door. And as the prosecutor pointed out, in between time, since it's been erected in this court, the cleaners have been wiping it, fiddling around with it, and it couldn't possibly be still considered an exhibit. The other point that was raised was that the gunshot tests were only done last week. A further set of gunshot tests were only done last week. When you think that this trial has taken more than a year to come to court, that seems incredible. I mean, Roger Dixon tried to explain it away by saying that, well, they'd got further evidence and their sort of putting together of the evidence was evolving, which actually played into the prosecutor's hands, that they were trying to fit together a certain story.
What should the defence be trying to do now? What would the strategy be from cases you've studied in the past?
They will continue trying to cast a shadow over the evidence given by the state, and they will try and attack every aspect of evidence presented by the state. And even if they just succeed on one point, it may cast a shadow over just about anything else. So it is not so much as trying to prove a ballistic point or a scientific point or not. It's just creating the atmosphere that what the state presented wasn't 100% good. It is questionable. They just need to cast a shadow. They don't have to prove innocence.
The ultimate onus of proof is on the state to prove beyond reasonable doubt. All that is expected from the defence is put up a defence, lay a foundation for it, and then follow that up with some kind of a corroboration to a certain extent. We're looking for doubt. If there's doubt in the mind of the presiding bench and the judge and the assessors, Oscar Pistorius must get the benefit of the doubt, regardless whether the bench, from a personal perspective, think or concur with the ultimate result or not. We've got a lawyer, we've got a legal trained expert sitting on the bench that must pronounce judgment here. And she might be inclined to say, I do believe the prosecution, but still, there's doubt in my mind on this and this basis, and therefore I must give him the benefit of the doubt in terms of our constitution and principles in our criminal law procedure.
The story goes on. Alex Lobo, thank you very much. Fascinating insight into the case so far and maybe what lies ahead for us. What lies ahead for us is that we should be back bright and early tomorrow morning, 8:30 BST, when the court opens again in the Oscar Pistorius murder trial.